Morning.
Good morning. Good morning. Okay, so we were in the middle of discussing the concept of shtarei berurin, which is basically the idea that many Dinei Torah are selected by the Zabla method. Each person selects one judge, and the two judges select a third. Locking in the judges is very important because otherwise it gives opportunity for any side to say midway through the case, I'm not interested in this. I'm going to go find another judge who will represent me. So the Ramah writes on page 64 that once the people put forth their claims, then you're locked into the judge at that point. Mishetanu b'fneim enin yachalom lach, so you can't go back on it. Furthermore, if you did an act of kinyan, if both litigants each received a handkerchief, and in return they obligated themselves to use the judge they've selected, then they've locked in. And the third approach, which the Mechaber writes, which no one argues with, is that if you write a shtar berurin, this is sourced from the Gemara, you sign a document that Ruvain chose this dayan, and Shimon chose this dayan, and together they chose a third dayan, and so on and so forth, then once you sign such a document, you're locked in. Okay, and we are going to discuss in a moment shtarei berurin and other things that are in shtarei berurin, and in the process of discussing that, we're going to take a bit of a sidetrack to another very important concept in Dinei Torah, modern Dinei Torah. When I use the word modern, I mean the last several hundred years, maybe even more. Page 66. They cite a Vilna Gaon on page 66 over here. This is a slightly different subject, and we're going to circle back to shtarei berurin in a minute. Rabbi Yossi, where the gray is. Rabbi Yossi bar Chalafta. The Vilna Gaon quotes Yerushalmi. Rabbi Yossi bar Chalafta was a Tana. Asun trained Barnash Midon Kamoi. So two people came in front of Rabbi Yossi bar Chalafta. They needed a din Torah. They had a dispute. They're coming. As we say, they agree to disagree without being disagreeable. And they want a court case. Amrle amenashe tidineni din Torah. So the two of them said to Rabbi Yossi bar Chalafta, we want you to be the judge in this case. We both agree on it. On the condition that you adjudicate this case based on Dinei Torah. Amrlo neni odeh Dinei Torah. Rabbi Yossi bar Chalafta said, I don't know the psak din. B'mei Rabbi Shimon ben Shatach, in the days of Rabbi Shimon ben Shatach was an early Tana. He lived during the time of the second Beis Hamikdash, approximately 75 years before the Churban Vayisheni. Nitzlu Dinei Mamaras, the acumen in precision in Choshen Mishpat was taken from us. And Rabbi Shimon ben Yochai says, the Leka Chakim Midon, there's no one, there's Shimon ben Yochai, we're almost up to Shimon ben Yochai, right? There's no one ready. Rabbi Shimon ben Yochai is the Talmud Rabbi Akiva, so he's 70 years after the Churban Bayis. After the destruction of Beit Mikdash, there's no one who knows, who's smart enough to do Dinei Torah. So what's going on here, right? We've been talking about Dinei Torah all along. And because of this, we have a principle, folks. And that is the principle of Pshara Kraiva Ladin. That is that Dinei Torah are adjudicated today based on that thing called what we call a Pshara. A Pshara is not what we call today a negotiation or a mediation, because mediation as used in America today, I think, is that both sides, right? Well, maybe it's a mediation, but negotiation is when we negotiate. That's not what it's talking about. It's going on. It's almost like an imposed negotiation based on what the Dayanim feel the Din Torah is. But they don't want to say that they're locking themselves into precision of Dinei Torah because we don't have that knowledge base anymore. That's already in the time of the Tanoim, they lost the knowledge base. Late Tanoim, let's say. Forget us today. That's point number one. Point number two, right? Okay, fine. Then there's another point we have to understand here. You look on page 65. He writes the following thing. If you look about 4 lines up from the bottom of the Kesef HaKadoshim, Menachno, Harei Adarabba Mishum Atruche Beidina Bechdi Lo Metrachinan. He says, we do not, I'm sorry, it's before where they underline in gray, I apologize. Okay, we don't just, as we would say today, you don't dray someone a cup. You don't dray a beis in a cup. You don't dray a beis to sit in a case where the whole thing is ridiculous. And therefore, if there's a scenario where we are afraid that someone's not going to listen and the whole din Torah will be for naught, the Dayanim could ask that money be put into escrow prior to a din Torah. Furthermore, Yesh laharshos leilechgam berko shal goyim sheyitzavo sheyachtemos atzvam. I don't know what that word is. Bekarfermes shal al dayanim. Val piro v'ayde chasim asyad kenichtav leil hu al tzara yoser toiv. Furthermore, you could ask them to sign on the Shtare Berin to agree to what the dayanim say. You could ask them to go to a secular court to enforce that they sign on Shtare Berin to agree to what the Dayanim say. This is like the idea of putting money in escrow. It's not considered going to secular court when what you're doing is just creating a scenario where we could enforce what the Jewish court says. Now let's go to the nusach of a Shtare Berin. So, if you look on page 67, you have here Shtare Berin, and they write that they decided to agree to these 3 judges as judges, and they write that this works through din Torah, uchesokef, whatever that is, hamoel al pi chukim emshala, could also work based on secular law. This is the idea that with a Shtare Berin, you get an arbitration agreement to go to secular court. Then in Aleph, look at clause 1. Habadatz, the beis din tzedek will adjudicate the matter, bein ledin, bein lefasher, whether kor din or whether a pshara, an imposed negotiation. And we'll discuss exactly how that pshara works. It's not just random. Val piosher, or based on how they decide to do it. The beis din tzedek could send out decisions. The beis din tzedek doesn't have to bring proof to why they decided what they decided. The beis din tzedek's decisions ein nitarim le'ur, cannot be appealed. Then they do a kinyan agav sudar. This is done with the handkerchief, right? We're doing belt and suspenders here. We're also doing the Ramaz idea of how you lock in the dayanim and everything that's agreed. And then, of course, they sign it with the dates, and both claimants sign it. They both sign it because we have a principle. Adam dami. The signature of a person is like 100 witnesses. So when you sign it, you lock yourself in. And this is the core Shtare Berin. Now, in this modern Sefer Seder Din, if you look on page 68, he adds that they throw in other things. First of all, they're allowed to write bein ledin, bein letos, whether to adjudicate this matter based on Jewish law or whether there's a mistake. We want to make pater the judges from judicial malpractice, if there's such a concept. And in fact, if you write in a Shtare Berin, you're going to do this based on din Torah, that's a mistake. That in itself is a mistake. We don't do dinei Torah today. We do pshara krova ledin. Okay? And then they write all the other things. A lot of them we mentioned already, that this idea, this situation is binding. Okay? So far we've established how we create a beis din and how we give teeth to the power of beis din. Now let's discuss going before beis din. So obviously when you go before beis din, you make a claim. In American law, if I'm not mistaken, we have something called an affidavit, correct?
Yeah.
Does that mean you don't need to appear in court under certain circumstances, right? You could substitute an affidavit. What is an affidavit? It's a signed document that says your position, correct? Is that right? Exactly. So let's discuss, does that work in Jewish court? So the first thing we're going to do is look at the Gemara on Makos Da'avavam beis. The Torah says in the pasuk in Parashas Shoftim, Al pishnayim edim o shlosha edim yokum davar. I'm sure you're all familiar with this pasuk. Based on 2 or 3 witnesses, a matter will stand. The Gemara on Makos Da'avavam beis, where the gray is towards the bottom, says, I'm going to give another approach to interpretation of that pasuk. Al pishnayim edim o shlosha edim yokum davar. Shelo tehei Sanhedrin shamas mipi dorkman. The pasuk says, Al pishnayim edim, through the mouths. You can't hear it from a translator. Beis Din has to hear directly the testimony of the witnesses without a translator. As Rashi says, the Dayanim need to recognize the language of the witnesses, and there can't be an interpreter between them. So the Gemara says a story. Rav was sitting in a din taira, and 2 people who speak a foreign language come in front of him. Rava said, I need an interpreter, and he put up an interpreter. Asked the Gemara, didn't we just get through saying, based on the Mishnah, Sanhedrin Shamas, Sanhedrin cannot hear through an interpreter? The Gemara answers, Rava made the Havoyadu Mad Havamri. No. Rava understood what the witnesses were saying, but he didn't know how to question the witnesses. He understood, as some people say, I have fluency in understanding the language, but I don't speak the language. He understood what the witnesses were saying, but he didn't understand how to respond and ask them questions. So therefore, you at least need to understand, not speak necessarily, the language of the testimony which you're hearing. Now, the Gemara, based on the pasuk in Shoftim, right, is only talking about what? About hearing from witnesses. We haven't addressed hearing claims of the litigants. We call that the Tanos Balei Dinim, the claims of the litigants. And this is discussed in the Ritva on this Gemara. Says the Ritva on page 71. Let's read the Ritva at the beginning. Yesh Omrim. Some people say that even though the pasuk is clearly talking about witnesses, after all, it says Al Pishnayim Edim Yokum Davar, who Adin Levalei Dinim, that's also talking about litigants. Why? Because if you read the story that's brought about Rava, it just says 2 people that spoke a foreign language came in front of Rava. The language of coming in front of means you come in front to adjudicate the case. So presumably they are the Balei Dinim, and yet the Gemara uses that as a question on the assumption that you need to understand the language of the witnesses. And the Gemara says, no, Rava understood it, but he couldn't ask them questions. That's why he had an interpreter. So presumably it's talking about the 2 people in a foreign language, those are litigants. So you see, the Gemara is equating litigants to witnesses. Albeit the pasuk is only talking about witnesses, the same halacha would apply to litigants, that the judges have to hear directly from the litigants' mouths. He says, V'chein das Rabbeinu Meir Levi, that is the opinion of Rabbeinu Meir, we call him the Orzura. Ume'ata, and he says now, Hu adin l'maisha amr ba'alma. Therefore, if we're saying that the interaction between the witnesses and the Jewish court has to be similar to the interaction between the litigants, just like the witnesses based on a pasuk in the Torah can't speak a language that the beis din doesn't understand, so too the litigants can't speak the language of beis din. Sorry, it's not the Rosh, it's Rabbi Ezrachi, it's Rabbi Meir Levi, yeah? So, therefore, other halachos about the interaction between the witnesses and the Jewish court should apply to the litigants, and that would apply to another thing we learn out of the pasuk. What do we learn out of the pasuk? Al Pishnayim Edim Yakum Davar, based on the mouths of the 2 witnesses, the matter should stand. Based on the mouths, we learn that that a witness cannot send a testimony via a sworn affidavit, and therefore, similarly, says the Ritva, we could derive that a litigant can't make a claim via an affidavit. If you remember, after the litigants say their claims in front of beis din, the scribes of beis din write them down, so the litigant can't go and claim something else afterwards to establish facts. But that's to record a fact. The litigant has to state it to beis din. That's what the Ritva says. Yeah. However, based on a shita of Rashi, He says like this. Rashi says, as he writes in the Torah, the following thing. What does Rashi say? Let's quickly get a chumash. Where's the chumash? Right here. What does Rashi say? Let's look it up. Oh. The pasuk says like this. That you have to hear directly from the mouths. What does Rashi say? Let's look it up. See if I can find it. Yeah. Says Rashi, V'lo sheyichtavu edusam b'igaris, and they can't write their testimony in a letter, sworn affidavit, we call that in popular terms, v'yishlachu lebeis din, and send it to beis din. And similarly, the litigants can't write it in a letter and send it to beis din. But what is the ritva medayik from Rashi? Something very interesting. Rashi only says that the pasuk al pishnayim edim excludes witnesses writing a letter and sending it to beis din. But let's say witnesses wrote a letter and came themselves to beis din with a letter, and they said, "Listen, Dayanim, for us to explain recite the entire matter to you, it'll take a half hour. We wrote it out in written form, and here it is." The implication is that's mutter. It's only to send the letter to beis din that's a problem, and therefore he wants to argue that if witnesses or litigants come to beis din with an affidavit, with their claims written out, their testimony written out, and they're there, and they say, "We are here, and this is what we wrote, and this is what we want to say," that should be accepted in beis din. That's not an exclusion from mipiyam below mipiyam ksama. Mipiyam below mipiyam ksama is only if they send it to beis din. That's the diak they make out of Rashi. Yeah. Okay. That's how he paskins. Okay. Now, at the very end, he says like this. He brings an opposing approach that the pasuk only applies to Edom, not to Dayanim. Fine. But Rameir already said it applies to Dayanim too. Then he says something else. And this is where our lovely attorney comes in. And the word, I frankly don't know what it means. So I ask you, it's not where the gray is, I'm sorry. It's about 5 lines up from the bottom of that paragraph in the Ritz for where the gray is. He says like this, even according to the view of Rav Meir, the answer, Aleph Nun Teslam Reish, I have no idea what that word is. I think we would say that's some sort of an advocate, or more sure, someone who's given permission by the Balei Dinim to stand in their place and state the claim in front of beis din. Lo chashav mipiyam b'torkim, and that's not a violation of not hearing it from a translator. The inu b'makom Balei davar mamishem, they're mamish standing in place of the person who has the argument. So this is a very interesting thing, that you could have someone who's morsha, who's given rishus or ansler. I really don't know what language it is. I'm so sorry. But the idea is it's similar to the concept of an attorney. Now, it's not representing, like the client saying you're representing him. It's standing in place of the client. I think we would call that power of attorney, correct?
Yeah, like attorney in fact. Well, I mean, too.
Is that what it's called?
Power of attorney, yeah.
Which means you could go instead of the person to court, right? Okay? Yeah. Now the Rivash has a Shiloh Tshuva. Here's a story. Shtei kitos bolodin. 2 groups came to make a judgment. Ha'achas morsha haba barsha masadet hanosav b'ksav u'mevakesh lochem la'asos din b'osanatainos. So one group comes with everything in writing, and the other group says, "No, I don't want the judges to accept anything in writing." He says, "No, we paskin that you shouldn't accept anything in writing." He says, first of all, it's not fair. If we're going to do this through writing, then the defendant's going to have to also respond in writing, and that'll be very, very expensive. Now, this is interesting, because in those days, it was very expensive to respond in writing. I don't know. Today, it's so expensive, you just write it out. Unless you argue that today, to hire your attorney to put your thoughts into coherent writing could cost you thousands of dollars. The judges should also hear the arguments that are written from their mouths, because maybe He gives another reason. Why is the whole idea you have to hear it directly from the litigant's mouth? That from the words, how someone speaks, the judges could ascertain if they're telling the truth or not. So if you come with organized claims on a piece of paper, then you'll have time to organize false claims with beautiful language. Rather, the judges should hear it directly from his mouths. The only reason the scribes are there are not to go back in it. So this Rivash seems to go against the diuk of Rashi. The diuk of Rashi is to fulfill mipiem v'lo mipik ksavam. Oh, if they're there, that's okay too. Here he's saying there's another nakuda. Even if the litigant show up in Beis Din with a written words, but they would have time to have organized those words. That's not what we want. We want them to speak directly to the judges, and the judges could ferret out whether it's the truth or not. And this is how we paskin in Shulchan Aruch over here. I'm sorry, we're running, but it's on page Siman Yud Gimel, Sif Gimel over here in Choshen Mishpat, that we pass like the Rivash. You cannot accept claims in writing, and as the Sma says, because we want the judges to understand if you're saying truth or you're saying sheker. Okay.
And they read it off a piece of paper that they're saying it themselves, but
that's very interesting. It's very interesting.
You have less emotion when you're reading it.
That's very interesting. It would seem to be you can, because at least they can figure out whether he's saying his truth. That's very, very interesting.
A lot of times you have a prepared statement.
Yeah, that's very interesting. Okay, we're going to continue on with this Morsha business Amir Shem either tomorrow or Friday. Everybody should have a wonderful day.